Ladies and gentlemen, we're going to go ahead and get started. A couple of preliminary matters before we start. Good morning. My name is Rob Litz on behalf of our team at USA&M. We're proud to put these best practice programs together and present them to you. Today is our 81st best practice program that we have presented over the past 17 years. We have another outstanding program for you today. The proceeds of these programs go to various nonprofit organizations, including Land of Lincoln Legal Services of Eastern Missouri, Beyond Housing, and food pantries, etc. Our interest at U.S. Arbitration and Mediation is really founded on education and presenting cutting-edge programs for our clients and the users of our services since 1985. The program today is part of that tradition, and we'll get started in just a second. A couple of other housekeeping matters. Those who are looking for their Missouri CLE credit, there is a certificate in your packet of materials. It's the second or third page, and on the bottom left, it reflects a program ID number. When you go online to submit your CLE credit, you'll need that particular Missouri program ID number. It's 689947. It's on the sheet of material that you have. Those seeking Illinois credit, Kelly Spiller of our office will be emailing a form to you, as well as an evaluation form to everyone. There is also a copy of the evaluation form in your materials. We always want to know how we're doing and what we can do to make these programs better in the future. We also solicit your ideas for new topics and new presenters to serve as speakers for upcoming programs. Speaking of future programs, you can mark your calendar. Our next best practice program is April 22. It'll be like this, a morning program. We currently have 2 out of the 3 sessions locked in. Bud Whittles, one of our new mediators, will be moderating a panel with Judge Mary Ott, the presiding judge in St. Louis County Circuit Court, and Judge Jeff Medler, an associate circuit judge. They're going to discuss the state of the art in St. Louis County and discuss their practices for taking civil, associate civil, and family law cases that are backlogged in the pipeline and how they're going to process those as we come out of the pandemic. We're also going to have a program by Cardina Johnson, another one of our new mediators, presenting a diversity, inclusion, and bias program that'll qualify for the Missouri and Illinois ethics component in that regard. The next thing I'll mention, you can put down on your calendars, June 22. We're going to do our second full day program on a variety of topics. Look forward to having you join us there as well. Without further ado, I'd like to introduce Steve Strum, who's going to be moderating our first panel. Steve's a partner at Sandberg Phoenix and a member of our USA&M mediator panel. Steve.
Well, good morning, everybody, and welcome to this morning's program. We're going to spend a little bit of time here talking about the new U.S. District Court, Southern District of Illinois mediation program, and then also court expectations for Zoom hearings and mediations. And before we do that, let me first introduce our panel. First of all, very honored and proud to introduce to you Chief Judge Nancy Rosenstengel. Judge Rosenstengel actually began her career here at Sandberg Phoenix, but she had higher expectations and we couldn't keep her. And so she moved on to the Southern District. She was first law clerk to U.S. District Court Judge Patrick Murphy. She then moved on and served as clerk of the court. And in 2013, she was nominated by President Obama to serve as a U.S. District Court judge in the Southern District of Illinois. She was confirmed by the Senate 95-0, back when they actually used to do things on a bipartisan basis. And she received her judicial commission May 12th of 2014. She is, I'm proud to say, the first female that has been appointed to the U.S. District Court for the Southern District of Illinois. She's the first female to serve as clerk of that court. And in 2019, she became the chief judge of that court, where she still remains chief judge. Judge Rosenstengel, thank you for being here today.
Well, good morning. Thank you for inviting me. We're excited to talk about the new program.
Absolutely. Magistrate Judge Beatty began his career as an assistant state's attorney in Madison County. He moved on and served as law clerk to Judge Patrick Murphy as well. He worked in private practice, and then in 2019 joined the court as a magistrate judge, where he sits today. And we're very proud to have you, Judge Beatty, and thank you for joining us.
Thank you for having us, Steve.
So let's dive into the wonderful world of the new mediation program at the court there in Southern District. And let's just talk about it. Rob, have you indicated to them if there are going to be questions, how those questions should be submitted?
Any questions can be submitted in the chat feature at the bottom of your screen, and I'll take a look at those, Steve, and then pass those on to you as we go forward.
That sounds perfect. Judge Rosenstengel, Judge Beatty, we're ready to proceed whichever way you would like to sort of give us an overview of this new program that you have there.
I'll just, let me start by saying, and then I'll let Judge Beatty kind of give a general overview, but we modeled our plan after some that are in other courts, but really personalized it for what we thought our needs were. So there was a lot of work went in with Judge Beatty and Deborah Ward, who was our court attorney, and I spent a lot of time working on it. So it's just getting off the ground. We don't have a lot to report, but we will be tracking the settlement rate, and we have to get some feedback to provide to the Administrative Office of U.S. Courts. And so we're anxious to see how it is, but Judge Beatty, I will just defer to you if you want to give kind of just a general overview of the program.
Sure, I'm happy to do that. So just, I'll try and just give a very 30,000-foot view of the program and kind of how it works, because as Judge Rosenstengel said, we modeled it after a couple of different courts throughout the country. Certainly, we looked to the Eastern District of Missouri, the Western District of Missouri. The district courts in the district in New York also have some very good mediation programs. And so we kind of pulled everything that we like together to put this plan together. So one of the first things that I think is unique about our program is that very early on in the case progression, the presiding judge will make a referral into the mediation program. So if you're familiar with litigating cases in the Southern District of Illinois, you'll know that very early on, after all of the answers are in, or the responsive pleadings are in, the presiding judge will enter a track order, which is basically like the case progression order. If it's assigned a track B, then that means the presumptive trial month is 11 to 14 months away. If it's a track C, I think it's a presumptive trial month of approximately 14 to 18 months, and it goes from there. So that's very early on in the case. And at that time, the judge will make a decision to refer the case into our mediation program. In other words, to say, this case is going to be subject to the requirements of our mandatory mediation program. And so I think that that's unique, because at that early stage of the case, that's going to then trigger the parties' obligations to begin meeting and conferring to determine who, an appropriate mediator might be for the case. And so just kind of moving through the case progression, after you have your Rule 16 conference with the court, I think it's 28 days from that Rule 16 conference, the court will expect you to have selected a mediator for the case. Now, it doesn't mean you have to mediate right then and there, but that way you've got the mediator identified for the case. If the mediator is a CMECF user here in the district court, that mediator will then appear on the docket as an interested party. And so they would then be able to get any ECF notifications when a filing is made in the case. As far as when we expect mediation to be completed, our program contemplates a deadline of 30 days before the discovery cutoff. So the idea behind that was to just give the parties some flexibility as to when they will conduct the mediation during the discovery phase. Thinking that some cases might be ready and ripe for mediation after written discovery. Some might be ready for mediation after party depots, and some might be ready for mediation later on. So the goal was to give a little bit of flexibility, but also have that deadline of 30 days before the discovery cutoff to have the parties take a run at mediation before then. So ultimately, they participate in a mediation on that day, at the appropriate time. If it's not successful on that date, we contemplate a window of opportunity for when they can continue to pursue mediations up and until the dispositive motion deadline, which, the goal being for the parties to mediate, ideally to resolve their case before they spend the time, money, expense preparing dispositive motions. And then so after that, then there's a couple of things that we'll ask the mediator to do, that we'll ask the mediator to file a stipulation or a report of mediation, giving us an indication whether or not the case settled, whether or not additional mediations are contemplated, and telling us kind of what's going on with the mediation process. So that's kind of the 30,000-foot overview of the program. And so, Steve, anything that you think I've missed or anything else you want me to talk about kind of as an overview?
Sure, I can ask some questions that will, sort of help guide the discussion here. First of all, I'm assuming that the website, that there's a link on the district court's website that will give the instructions that you're talking about, the documents that need to be filed, things of that nature.
Yeah, we have I think it's a tab, or I think it's a flag at the top of our district court website that, in red, that says new mandatory mediation program. And so when you click on that, that's also going to provide you a link to the mediation plan, which is contained in an administrative order from Chief Judge Rosenstengel. And then it's going to have all of the different forms that we're looking for from the parties, and other, form selecting the mediator that we ask you to file, the form for the mediator to complete upon the successful completion of mediation. And the mediation plan also gives the deadlines for when we ask the mediation to be complete.
It does seem quite similar to what we have in the Eastern District of Missouri. There's one thing that the three of us talked about recently, and that is the change in rule in the Eastern District of Missouri related to mediation participants having to have their video and their audio in the on position at all times. You all don't have that yet. Is there a contemplation that may be coming?
Yes, so we are in the process of revising our local rules. They're horribly out of date. And we've been trying to we have a committee formed and we're working on revisions. And I passed that along to the head of the committee for consideration. There's a lot of things that need to be updated in the local rules. So I encourage, if anyone has a suggestion for that, let me know in general, anything with the local rules. But we do intend, I would think we will address it some way. Right now, that is just up to each, the mediator, if it's going to be by Zoom and the rules and that, but I think it's likely coming, yes.
Okay, all right. And I know that you all mentioned, sort of looking at other courts, and the Western District of Missouri was on the list there. And I, not to be critical of the Western District, I do like your program. I like the Eastern District program. One of great things about it is that it gives the lawyers the opportunity to decide when is the best time to mediate the case, as opposed to some places where you have to do it so early that people are not able to really even assess the case to make the determination as to what the value of the case is. So I commend you on that. What if a party or parties decide that they want to opt out? Are they able to opt out of this program?
They are. Well, they can. Do you mean opt out completely? And
Okay.
Yes. Yeah, opt out of the mediation program.
no.
Okay.
Well, they'd have to file a motion for and show good cause. But I think we've allowed the good cause standard to be determined by the presiding judge, and each judge can have their own threshold of what they think to be good cause.
And we've spelled that out, that it's a pretty high threshold to meet. Let me just say one thing about the timing, because that was important to us, that the parties can decide. And at least in my mind, one of the goals is that by selecting the mediator, and there can be a discussion with the parties of, okay, well, when will you be ready? Because I'll have status conferences, and before we had this program, do you want a referral for mediation, and hear different things about, well, yeah, we're ready now, or we need to depose this person, or so there is a lot of flexibility. And the other thing that I think is maybe unique to our plan, we don't have a maximum rate or a minimum rate or required rate at all. We really took the let the market bear approach. And so the mediators are all on the website. They can put their experience, what their rate is, and the parties then can pick a case pick a mediator that really fits their case with respect to the experience that they had. And of course, there are some cases where people don't want to pay very much, and others where they're happy to have someone with a lot of experience who charges a higher rate. So I think that hopefully, as we go forward, will accommodate the needs of the lawyers in all of our cases.
What if the parties cannot agree on a mediator? What is the next procedure?
So the process for that is that they can notify our program through an email to the mediation, our mediation email account. And I think we have some specific criteria in there as far as what we ask them to put in the email, as far as tell us, the case name, tell us your what's going on as far as whether you can't meet a mediator, or whether you've identified 3 mediators. The plan speaks to that, but I know I have had, just from my own personal experience, I've had a couple of instances where they've indicated to me that they were having trouble agreeing on a mediator. And so what I've done in that instance is said, okay, well, if you can't agree on a mediator by this deadline, I'll just go ahead and pick one for you. And each time they've been able to agree before I just end up picking somebody.
Yeah, no doubt there. What if they decide they want to use a mediator who's not on the approved list? Can they do that?
So that would come back to the opt-out motion. And I think we crafted this, a couple of thoughts went into this. And as the chief said, we wanted to have a broad panel of mediators, and we wanted to entice mediators as well to come to apply to our panel by not meddling in their rates, and by not saying, for example, you need to provide all of your prep time at a reduced rate, or you need to provide the first 2 hours at a reduced rate. We really wanted to avoid meddling in that. And so with that kind of context, we have this opt-out process where the parties can file a motion to opt out, but they do have to establish good cause. And for example, I mean, if it's an MDL and there's a unique special master or mediator that might not be on our panel, that might be an example. there, but we wanted to set the standard to be good cause and then give the judge the discretion to whether he or she believes that good cause has been met to employ a mediator who's not on our panel.
And
Anything
there is
you
a
want to
form
add,
out. Sorry, I was just going to say there is a form that the plan links to called attestation regarding private mediator. So you basically have to, there are cases maybe where that's appropriate, but like Judge Beatty said, we're trying to get a robust panel so that doesn't come along. And just going back to the complete opt-out too, the plan contemplates that if the parties are wanting to opt out of the plan entirely, that those should be filed prior to the Rule 16 conference so that the judge can take them up at that time. So for new cases, when you're approaching the Rule 16 conference, you would want to file that before you have the meeting with the judge.
That's a good point. I was just going to make that the distinction there between opting out of the plan completely and opting out of our panel mediators is a different provision within the plan.
And it is, if I read this correctly, it's contemplated that the parties will actually mediate the case for a minimum of 2 hours. Is that correct?
That is.
Okay. All right. Let's talk about attendance. We have cases where there's representatives from defendants, representatives from insurance companies, lead trial counsel, associates working on the file. What is contemplated as to who is going to be attending the mediation?
So the plan says that all named parties and their counsel are required to attend the mediation. It leaves it up to the mediator, whether it's in person or by telephone or video. And then we address as a corporation or other entity, a corporation or other entity satisfies the attendance requirement if represented by one or more persons other than outside counsel who have the authority to settle and are knowledgeable about the facts and circumstances of the case and the claims being made. So I don't think and then I should say, as far as your question goes to associates, the plan also says that each party shall be accompanied at the mediation session by the attorney who will be primarily responsible for handling the trial of the matter or is most familiar with the matter at that stage of the proceeding. So it contemplates it would be the lead lawyer. Of course, others could participate as well.
Yeah.
Edie, anything to add to that?
Just one additional point I wanted to add on that. On the attendance and participation section of our mediation plan, there is a provision in there that says the mediator may require the attendance of any other individual who appears reasonably necessary for the advancement of communication and resolution between the parties. So again, empowering the mediator to say, when he or she has looked at the mediation statements and say, well, look, I think this person needs to be here. And I'm going to require that you have this person here to participate in the settlement negotiations. Again, the goal, empowering the mediator to set their criteria and their rules. Yeah,
I think that's a wise way to do it. And so just to recap, I mean, most importantly, obviously, we need somebody who has the authority to settle. We need to have lead trial counsel, and perhaps sometimes lead trial counsel doesn't quite have a complete grasp on the case at the time of mediation, so may require an additional person to be there who has the knowledge of the case. And then, as you said, the mediator who may decide somebody else in the world of either party or any party should also be there. Okay, good.
Right, and just a note, there is a separate section 2 under attendance and participation about the proper representative insurer. And of course, like you said, that any representative, including an insurer, is required to attend if their agreement is necessary to achieve settlement. They have to have knowledge of the facts and the claims being made. And then it also says if it appears to the mediator that a case is not being reasonably evaluated by the representative present, the mediator may meet privately with one or both sides to determine the analysis that has gone into the evaluation of the case, including the names and authority of the individual involved in that analysis, and the mediator can then request that those individuals. So beyond just maybe something jumping out, if the mediation starts and it appears that there hasn't been a reasonable evaluation, then the mediator has some options there.
And then at the conclusion of the mediation, I assume that whose obligation is it to file something with the court, and what is it that they are to file?
So after the conclusion of the mediation, I believe that there is a report that the mediator has to file, and that is available on the forms website.
It's called Report of Mandatory Mediation.
That's right, there it is, yeah.
Okay.
If
That
mediator is not a CMECF user, we ask them to email that to our mediation inbox, our mediation email inbox, and then somebody will file it. If they are a CMECF user, they can simply just file it on the docket.
And we've mentioned that a couple of times. That email is just mediation@ilsd.uscourts.gov. So.
all right. And if any of the attorneys or the mediators have questions regarding an issue as they're proceeding, where do they direct those questions?
Well, I guess if it's a general question about the program, we do have that email address. We are currently in the process of hiring a court attorney who will have a lot of responsibility for facilitating this plan and, you know, answering those types of questions. Depending on what it is, I suppose you could ask for a status conference with the presiding judge. But there is someone monitoring that email box all the time, and it would come to somebody in the court who would be able to answer it. Judge Beatty, do you have any other thoughts on that?
No, I think that's a good point. You can send the email to the mediation inbox, and whoever's monitoring it can look at it. And then, of course, you can always request a status conference with the presiding judge to address it that way.
Steve,
Rob?
we have a question in the chat, and that goes to a case out, for example, an auto accident where the named defendant is represented by the insurance company and the insurance company's attorney. So while they're the named defendant, does the program envision a requirement that that defendant be present, even though they are represented by their insurance company and counsel for the insurance company?
That's a good question. I don't think a fair reading of the plan would require that. Again, that would kind of be the mediator. I mean, if you have the attorney and the appropriate authority from the insurance adjuster there, if your mediator looks at the case and thinks, well, this person should be here and perhaps may have a good reason why, that would be a good way for that to fall into the other attendees category. But I think that as far as the named defendant and the auto case is assuming that there's no issues with coverage or anything like that, and you've got the proper insurance representative and the proper counsel there, I think that would be sufficient. What do you think? What do you think, Chief?
Yeah, that is a great question, because the plain wording of the plan that it says all named parties and their counsel are required to attend the mediation. But in that situation, that's just something I would raise with the mediator because we didn't intend that. I mean, there's no reason, because in that case, that person wouldn't have any say as to whether the case got settled or not. I don't see that they would be necessary, but that would be something to raise with the mediator.
Yeah, so it's not a requirement that you all are pushing. It's really, as you said before, it's giving the mediator, the control of the mediation, deciding if it's appropriate or inappropriate for someone to be attending. It sounds like the real key is you want, on the defense side, somebody to attend who has the authority to settle the case.
Right.
Rob, were there any other questions?
There's one other, and that is whether the judges could explain why class actions are not subject to automatic referral to mediation.
Wow.
Maybe they should be.
Yeah, I guess maybe our thought process there, Judge Beatty, correct me, because like I said, we spent a lot of time developing this, was just that those are so unique in the way, we have a separate track assigned to them and everything. So I think our thought was just that they're so unique and complex that at least at this time, as we wanted to get the plan off, that they would not be included. Judge Beatty, do you have any other memory?
No, I think that's exactly right, because as Judge Rosenstengel said, we have a scheduling order unique to class actions in this district, and a scheduling order obviously unique to regular civil non-class actions. And the thought process in that is that, again, the presiding judge would have the authority to refer the case into the mediation program, but our scheduling order for class action cases, contemplates discovery on class certification. Oftentimes you're going to see an extensive briefing schedule on class certification. And it's maybe an instance where the judge can meet with the parties early on in the case and say, look, and get a feel for, is this a type of case that's going to be amenable to settlement resolution before class certification has been decided? If so, then they could refer the case into the program. But again, coming back to the scheduling order, you're going to have to craft some unique deadlines as far as when mediation might be required in a class action case. It just doesn't fit so nicely into our typical scheduling orders for regular civil.
Judges, it is interesting because we've had the opportunity to mediate class cases, and they're really in two bucket categories, and each one of these cases are different. And Judge Rosenstengel, I think you really hit it on the head, is that they are unique. Some of these are ripe for mediation before class certification, where the parties would consider an individual settlement. And then when they are certified, that's a different ballgame, and a different approach to mediating those after class cert. So they are unique, and it's clear that the court is interested in having those mediated. It's just not on your automatic timeline under your regular order.
That's right. So they can be sent there, but we just didn't want to make it mandatory at the very beginning because they are unique.
Steve, those are all that are in the chat. And folks, if you have other questions, go ahead and just jot them in the chat.
Perfect. Well, then why don't we move on to the court expectations for Zoom hearings and mediations, and see if we can get through this without my cat actually jumping on my lap right now. So, in fact, I think my first Zoom mediation when this lovely pandemic began 2 years ago, Judge Beatty, was with you. Back when I think you sent your family off somewhere so you could have a quiet house. But besides animals and kids and quiet houses and doorbells and all that stuff, let's talk first about, decorum, wearing a tie, wearing a jacket, the expectations that the court has, because we are going to be, I think, living in this world of Zoom and video conference for quite some time.
Well, I would say I would always err on the side of being dressed as if you were in court or you were coming in person. Some judges are probably a little more relaxed about that than others. But certainly, and for this group, it's probably not really an issue, but things happen with, I would, during what I call, true COVID, the beginning of COVID, I would hold hearings and things from home with the dog right next to me, just praying nobody came to the door because I knew it was pretty. But You know, I would say mute is a huge thing. The number of times in the last, you know, almost 2 years, I've had to say, you're muted, you're muted. The lawyers just start talking and they're on mute. And, you know, it happens. I think we've all gotten to the point now where, like, the sophisticated group that's in this hearing, you can work Zoom pretty well. You know, I encourage you to master it, because it's also frustrating when a lawyer can't get on and then they're calling their assistant to come in and help them. And so, you know, that I would just approach it as a court proceeding. And I say this doesn't apply to this group, but I know Judge Beatty shares this with one of our greatest frustrations when we're doing video conference with someone in a jail. You know, the guards will be in there with the radios going off, the phone ringing, conversations carrying on. And, you know, I get really frustrated because that wouldn't be happening if we were in the courtroom. But, you know, I would just say, you know, try not to have your, you know, your dog barking or your phone ringing, the house phone ringing, or, you know, mute your cell phone, and just approach it professionally, because I do think, I mean, Zoom is here to stay. I mean, people didn't know it in March of 2020, you know, weren't familiar with using it, but it really opened my eyes. There are a lot of hearings. I'm like, why did I ever have this in person? Because it's so easy, especially like I have an MDL case. There's lawyers all over the country. We meet once a month for a status conference that doesn't even take, well, I meet with leadership, that maybe takes half an hour. Then I have the full meeting with anyone who wants to attend. That's like 10 minutes, and it's just so efficient. But again, you know, you expect everyone to have their camera on and be dressed as if they were going to court.
Judge Beatty, how about you?
Yeah, I think that I would echo everything Chief Judge Rosenstengel said, and a couple of thoughts that I had. And coming back to the you know, dressed appropriately, I think that that's important, and we see it more often in the criminal context than I think we do in the civil context. And the reason being is that when you have litigants on a hearing, people who are parties to the case, or for example, a criminal defendant who is on a Zoom hearing, I think it's important for that person who's not necessarily familiar with the court process to look around and to see all of the attorneys, the appropriate court personnel dressed professionally, because you can lose a little bit of a sense that we are in court right now when everybody's just on the Zoom screen. So I think that's when attire comes into play, reminding folks, reminding the litigants, reminding the criminal defendant that this is court, this is a court proceeding, and it's important to conduct yourself appropriately. And as far as just you know, other things, you know, dogs jumping and phones ringing, you know, I think that that's where the mute button certainly comes into play and is very handy. And I think also, as Judge Rosenstengel said, I think Zoom is certainly here to stay for a lot of different options. Even just the many things that we used to do by way of telephone too, for ease and efficiency of the parties. It's just nice to do it via Zoom. And when you have a case, like Judge Rosenstengel said, if you have an MDL, or I have a couple of class actions where there's, you know, 10 to 12 lawyers on the case at any given time, it can be kind of awkward when you're doing a phone conference and then somebody starts to talk and then somebody talks over the other and nobody knows who's going to talk next because nobody can see in facial expressions. That's where Zoom comes into handy, just having these status conferences when you've got a lot of parties in the case, because then everybody can see, oh, that person was about to talk right now. I'll wait and not interrupt that person. So I certainly think that Zoom is here to stay as well.
I guess one of the other things that I've noticed, and I tell the lawyers in my office, is, you know, your cell phone, you know, you would not be looking at your cell phone if you were in front of a judge. So put your cell phone aside, turn it upside down, put it in a drawer, but don't have it in front of you unless for some reason it's needed for the actual hearing, which usually is not the issue. But You are to act as if you are in the courtroom when you are on a Zoom meeting with the court.
Right. And I'll just add a couple things. First of all, this I think has gotten better too, and for all of you, it probably doesn't apply. But, when somebody doesn't have a very strong Wi-Fi signal, that's really frustrating because they keep freezing up or they have to disconnect and reconnect. So, it's time to spring for some good Wi-Fi because it is here to stay. And, like Judge Beatty's point, it is helpful when there's a lot of parties. And, some of the things it can't be helped if there's noise, but that's what I mean. Master the mute button. Know when to have your, mouse on it, ready to hit it if something happens, and be able to turn it off quickly. I don't know how many in our audience do any multi-district litigation work, but when they've been having their Zoom hearings, and I thought this was interesting that, it used to be that the lawyer gets up and does a short presentation arguing why a case should go to one court versus another. And what they've done now is, so the person would get up, start their thing, and just like an appellate argument, the judges on the panel could just immediately pounce with questions. And the way that Judge Caldwell, who's the chair of the judicial panel on multi-district litigation, has handled it is the lawyer now gets to make their complete spiel, and then she goes one at a time on the judges to ask questions. So I think that's probably beneficial for the lawyers. They can get out their introduction and then go one at a time. So that's one of the things I like about Zoom too, because you have a little better control than, as Judge Beatty said, when people are on the phone and just talking over each other.
Well, and I know that clients love it because they're now starting to see it as a cost savings. So they're not paying lawyers to travel, not paying lawyers, hours to go up to court when they can just spend a few minutes on a Zoom call. So I think it's wonderful. And I guess it's maybe the only positive that's come out of this pandemic. Rob, any questions from the panel or from you?
So one question or comment in the program talks about having counsel, parties, insurers being present, and the mediator can, request that they be online during the mediation itself. What has been frustrating, and I'm sure all of us have been involved in these, where someone hooks into the Zoom on their phone and you're sitting there mediating their case, instead of seeing their face, their phone is on the coffee table and you see their fan spinning around. We do our best work when they can see us and we can see them. The concept of a mediator who had his laptop just on Monday, a case I had, he had it facing him. His clients were directly behind the camera. So they needed to see me and I needed to see them. And it was very simple. I asked the lawyer to move a chair next to behind his client so we could all see each other. And I think that dynamic is important with a video mediation versus us being in conference rooms.
We've also become not just lawyers and counselors, but film directors.
I was going to say, don't zoom in on your phone. We've had that on your phone while you're driving, on your phone while you're driving. We've had that too. And again, you wouldn't be doing that if it was a court hearing, and besides, it's dangerous.
Yeah, right.
Steve, we've got about 5 minutes left or so. I know you also want to chat about some of the statistics and things going on at the court.
Yeah, Judge Beatty, I think you and I had talked about that. I don't know if you were able to pull some statistics. We were talking about sort of, statistics in terms of the historical filings and settlements and things like trials and things like that. If you could just talk for a few minutes about that.
Sure. This came up in the context when we were talking, and the chief judge and I were working on answering some questions for the Illinois State Bar Journal article. Our Illinois State Bar Journal was doing a write-up on our new mediation program. And I forget what the exact question was that prompted it, but as a result of it, we started looking into the I forget what website it is through the courts or through the Administrative Office of Courts, but it tracks trials nationally in the United States District Courts. And one of the things that we had noted was, and the statistics were so in 1962, on a national average, civil cases were tried at a rate of 12% in federal courts. So that's in 1962. Ever since then, they've been declining. Now in 2020, the last year that I was able to find, less than 1% of regular civil cases actually go to trial in federal court. And that was not just related to the pandemic in 2020. In 2019, I believe it was 0.7% of civil cases go to trial nationally in federal district courts. And so the context was of that is that if you look at the likelihood of how a case is going to resolve, I mean, it's almost certain to either resolve by way of a mediation or through some form of motion practice. If you're talking that less than 1% of cases actually go to trial in the civil arena, the betting person is going to bet that it's going to resolve in a way that it's not a trial. And so that was another reason why we thought, having this mediation program is so important, because that's the likely way this case is going to resolve, and we can help incentivize and create an efficient resolution for these cases.
Yeah, and to get that conversation started early on, like we said, of course, there are some cases where something has to be done, but at least, it's frustrating for everybody when you get all the way up to the eve of trial and suddenly the case settles when it likely could have before. And, we don't have a way to separate out, but I would say with that statistic, the regular, what we call regular civil cases, which would be what most lawyers are practicing, is even lower, because at least here in the Southern District, I would say probably upwards of 95% of civil cases that get tried are prisoner civil rights cases. So it's those go to trial because, we are at a point now where some of them settle, but a lot of them don't. So that represents a lot of our percentage. And I'm sure throughout the country.
Perfect. Rob, any questions?
One more question, and this comes up rarely, but it does come up, and that is when one party at mediation points out that whoever on the other side, client representative, insurance representative, did not have knowledge of the file, did not have appropriate settlement authority. And the lawyer, of course, on the other side is saying that that other party is not negotiating in good faith. Sometimes they'll ask the mediator, well, you need to advise the court, Mr. or Ms. Mediator, that they didn't negotiate in good faith. They didn't bring appropriate people. Most of us as mediators are going to say that the mediation was held and it did not result in a settlement, and usually suggest it's the lawyers who need to point this out if they want some remedy. Do the judges have any thoughts if a lawyer files some type of motion for sanctions for an opposing side not bringing the appropriate person to mediation, what that process would be for the practicing lawyers out there?
That's a good question. I was thumbing through our plan to see, I believe that there was an option for the mediator to submit a report if they believed that a party had failed to appropriately evaluate the case or failed to conduct the case conduct their mediations in good faith. I suppose the question is more asking if a party just takes it upon himself, that party's self, to file a motion with the court for sanctions.
Right.
Yeah, the report of mediation does have, I pulled that up, does have a box basically to say, other, you can say case settled, mediation was inconclusive, and another session has been scheduled. It's complete, the case did not settle, or other. So if the mediator wanted to report some sort of bad faith, I think that that would be a vehicle to do it. And, you know, if I would say a lawyer could just file a motion if they felt that that was the appropriate way to go.
We haven't seen it yet, so that will be a motion for a first impression for either the chief judge or me, I think, on this, under this plan.
Historically, mediators are leery of advising the court of what occurred within the mediation. I'm told that there may have been only one such report filed in the Eastern District over the years. And the mediators have taken the approach in the Eastern District cases that if there's an issue, it's really for the lawyers to raise that with the judge.
Yeah, I just found this section, it's section 2.3 of our plan. And it says mediator or party may report to the presiding judge any failure to attend a mediation conference, to substantially comply with the order, or to otherwise participate. And with an accompanying declaration should be sent to all parties. And then it says the court, upon receipt of such a report, the court may take whatever actions it deems appropriate, including issuing an order to show cause why sanctions should not be imposed. So that's out there. Fortunately, we haven't had it, but you know, it's only been around for like 4 or 5 months now.
Very good. Steve or the judges, any final comments?
Judges, anything?
I don't have anything. I just encourage anyone who's interested to join our panel because, you know, that gets out if somebody wants to hire you, that you're on the panel. You don't have to go through the good cause determination. And again, we don't meddle in your rates. You can charge whatever you want to charge and just tout your experience and credentials to make yourself, you know, attractive to be selected by someone. And if anyone does have suggestions about changes to the local rules or anything, even with the mediation program, you can email either the mediation email, which is mediation@ilsd.uscourts.gov, or my chamber's email is njrpd, as in proposed documents, @ilsd.uscourts.gov. That's on the website. But thank you for inviting us. And again, I just encourage everyone to join our panel, and we just want to keep making it more and more robust. So, Judge Beatty?
No, likewise, thank you for inviting us. Thank you for giving us this opportunity to speak with you all and tell us about our plan. And again, likewise, if you have any questions, submit it to the mediation panel email, or you can submit it to my prop docs email as well. The chief judge and I are both keeping a careful eye on that mediation panel email and keeping close watch on the program, because we both want to make sure that it's a successful program. So thank you.
Yes, thank you, judges. We really do appreciate your time, and it has been very informative. So we really do appreciate that.
All right, thank you. Have a wonderful weekend, everyone.
Steve, judges, thank you so much. We're going to take just about a 5-minute break, and we'll start the next program at 10 o'clock. Thank you all.
All right, thank you.
Thank you.
All right.
Folks, why don't we go ahead and get started? Couple of other housekeeping matters. In addition to the best practice programs, occasionally we at USA&M will co-sponsor other seminars, webinars with other organizations. And literally just yesterday, the final information came together. On March 4 and March 18, USA&M will be co-sponsoring these two programs with the Washington University Public Interest Law and Policy Speaker Series, which have various programs throughout the year. The other co-sponsors for that program are the WashU Journal of Law Policy and the Mound City Bar Association. Last month was the 100th anniversary of the Mound City Bar, and the the Journal on Law and Policy at WashU has this upcoming issue that focuses on a number of topics relating to, especially because this month is Black History Month, a variety of topics. And the seminar on March 4, it will be at noon for an hour and a half, will include Anne Marie Clark, Colin Gordon, Judge Willie Epps, retired Judge Sandra Hemphill, and Ebony McCain, Judge Nicole Colbert Botchway. The program on Friday, March 18, also from noon to 1:15, we'll have David Koenig and Judge David Mason, Professor Kim Norwood and her husband Ron, Denise Lieberman, Sandra Moore, and Lisa Hardwick. There'll be some more information coming out on both of these programs in the next week or so, and I urge you to dial in for these absolutely tremendous programs. Each of those speakers are authors of articles in the journal, which is also just coming out. And it's really a matter of pride that USA&M could participate as a co-sponsor. The next program is on ethics. I'll let you know from a housekeeping standpoint that as the Illinois ethics application process, we submit the materials that Chris Stegemeyer, our speaker, provided to us. It takes the Commission on Professionalism from the Supreme Court a little bit of time to approve that. So Illinois has the approval is pending. Missouri has already approved all of the 3 hours today for credit, including the CLE credit. Without further ado, Chris Stegemeyer is the head of risk management at the Bar Plan. Chris is a graduate of the St. Louis University School of Law and has been kind enough over the years to share his time and his experience in our best practice program, and has agreed to present a program focused on lawyers' duty of communication. Chris, it's all yours. Thank you so much for presenting.
You're very welcome, and thank you for the opportunity to speak here this morning. The topic that I'm going to be discussing, the duty of communication, is one that I know every practicing lawyer understands is one of, if not the most frequently cited, for example, ethics alleged violation, at least. So I'm not going to talk about it from that point of view. I'm assuming that every lawyer here knows that you need to talk to your clients a lot and often. But rather, what I'm trying to do with this material this morning is to help you develop a different, maybe perhaps, understanding of what it means to communicate, really, per the rules of professional conduct, and certainly then also to get into issues of client consent to really anything in the attorney-client relationship. I wanted to start off with a quote from the it's Bloomberg BNA, and it discusses the idea of communication. And you can see the quote there: almost all disciplinary proceedings alleging violations of Rule 1.4, obviously in Missouri 4-1.4 communication, also involve violations of several other ethics rules. The other violations often explain what the lawyer has failed to tell the client. And the point of the quote is to illustrate exactly what I'm talking about. That is, if the lawyer had truly met their duty to communicate with the client, there wouldn't have been any other violation. And oftentimes lawyers think that they are communicating with the client in the way the rules require, when in fact they are not. So let's take a look first at the following rules, 4-1.4 communication and 4-1.0E, which is the terminology section of the Missouri Rules of Professional Conduct, and specifically informed consent. The duty of communication rule states that a lawyer shall, 1, keep the client reasonably informed about the status of the matter, promptly comply with requests for information, and consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows the client expects assistance not permitted by the rules of professional conduct or other law. So let's hope number 3, subparagraph 3 never happens to you. Further, a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. See a little asterisk there. That is my asterisk. It's not in the rules, and you'll see in a moment what I'm talking about as we move forward here. So one way to think about a shorthand explanation of the lawyer's duty of communication under the rules of professional conduct would be, first, inform the client. Now, because I'm going to be presenting this material multiple times, I've decided just right now in this moment that when I do it in the future, I will have a definition of inform so that lawyers will understand in greater detail what it means to inform. What is the definition of that word? Consult, explain, and respond. Now, I think, once again, when lawyers think about violations or ethics risk or exposure and also malpractice liability, in conjunction with communication, the failure to respond, that's the one that everybody thinks is the big killer. Well, it's a big enough one. We'll just say it. You need to respond to your client when they make reasonable requests for information. But a response that doesn't inform, if it needs to inform, a response that doesn't consult, if there needs to be consultation, a response that doesn't explain, if there needs to be explanation, isn't a response. So the lawyer has accomplished nothing in responding if inform, consult, and explain have not occurred inside that response. This case from 2016, they call them a grievance in Maryland. The lawyer had a grievance filed against her. The allegation was that she had not communicated with the client. The lawyer argued that she had no duty to communicate with the client in writing as opposed to orally. However, the lawyer knew that the client had trouble understanding and retaining spoken information. And what the court held in that situation is that a lawyer's failure to put her advice in writing violated Rule 1.4b. That is, that the lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So that's just an example. If you're talking to somebody, but they have any kind of a condition that makes it difficult for them to understand what you're saying or retain what you're saying and then be able to act on it in the future, it doesn't make any difference that you've talked to them. If it needs to be in writing, then it needs to be in writing. And this is just an example of how sometimes there is I believe, a disconnect between what lawyers perceive as their duty of communication and what the actual reality of their duty is. There are a lot of comments in 1.4 under the duty of communication, 4-1.4. One of the things, my kids, it drives them crazy when I'm sitting here at home, working on a program, putting material together, and they walk by and they see my screen and they say, Dad, you're putting too much information on that PowerPoint slide. And I tell them, I'm talking to lawyers who are smart people and know how to deal with a lot of information. So, and I will never, ever, ever do a PowerPoint slide that has an animal on it. So forget it. Anyway, so if you have not read the comments to the 4-1 point rule of on communication, it's important to do so. But once again, it's important not to just read them as a comment. It's rather important to read them and almost with every sentence, stop and ask yourself, how do I do that in my practice? How do I do that with my clients? How do I do that in my firm? How do I do that in my area of law where I practice? And then in the communications that I do regularly with my client, and I will tell you right now, the most regular communication that lawyers have with their clients will be their fee agreement or their contract. That's the most regular form of communication that lawyers have with their clients. By the way, my experience tells me most lawyers' fee agreements are really crummy. They're no good. And very often they end up causing immeasurably more harm through the lawyer's complete misunderstanding of what they are able to do and what, depending on the level of communication inside their attorney-client relationship based on some stupid boilerplate writing that they give to a client and say, read this and sign at the bottom and let me know if you have any questions. Lawyers' fee agreements are just atrocious. They don't work as contracts and they end up basically just being a fertile ground for ethics violations. So anyway, one of the interesting parts of the comment to the rule on communication that you see highlighted there in red that I think can be a difficult one for lawyers depending on the nature of their attorney-client relationship and their area of practice is that even when a client delegates authority to the lawyer, the client should be advised of the status of the matter. I cannot tell you how important that phrase status of the matter is. That's the crux of so many problems in communication, that the lawyer does not communicate the status of the matter. One of the duties, for example, that a lawyer has in communication is, from our perspective, certainly at the bar plan, mutual insurance company, and then from a risk management standpoint is what does a lawyer say or have to say to a client if there's a material error in the representation? Well, that's the first thing that we tell our insureds to do is advise the client on the status of the matter. First of all, I've had so many lawyers over the years stop me at that point and say, wait, my malpractice insurance carrier wants me to tell my client about the mistake? Absolutely, because you have to. Now, I don't want to get into it here this morning, but there's an entire art to the nature of the communication. But it starts with advising the client on the status of the matter. What does that equal? See, once again, this is one of the reasons I may be a little bit jaded about how lawyers communicate with clients, because when I say that, when I'm having a conversation with one of our insureds and I say, there's a material error, you have a duty to advise the client on the status of the matter. And then they start to give me what they believe the status of the matter is. In that, no, what you've just given me is your opinion about why you don't think you have a problem here. That's not the status of the matter. That's an opinion. The status of the matter is going to rely on objectifiable fact, for example. But anyway, so one of the things that then also comes up, and I do see this fairly regularly, you see another asterisk there, is that a lawyer that was hired by the client's girlfriend to represent the client was fired by the girlfriend. And the lawyer failed to contact the client to communicate the discharge or confirm it was the client's decision. Remember where your duties run. In terms of communication duties, that's a really that's like step two. Step one is, what must I communicate? How do I inform? How do I consult? And so forth. And so step two then is, where do my duties run? Who do I have to talk to? And then you get into this circumstance where another huge issue is the lawyer's duty of confidentiality of information, and the lawyer's duty of attorney-client privilege on communication. And note the difference there: confidentiality, information; privilege, communication. And it's very important to understand that distinction, obviously, when you get into communication settings. So that raises then another good point. Let's see. Just in terms of what come under the heading of best practices, which is a phrase that I hate. What's your best practice recommendation? Well, what's the best for you? That's always where I'd like to start. But let's just say there is some such thing as a best practice in communication. So what can you do inside your law firm? Well, if you look at comment 4, when a client makes a reasonable request for information, the rule requires prompt compliance with the request, or if a response is not feasible, that the lawyer or a member of the lawyer's staff acknowledge receipt of the request and advise the client when a response may be expected. There's another asterisk. Let's see what's coming here in just a second. A lawyer shall promptly respond to or acknowledge client communications to the lawyer. So yes, there are times where a lawyer cannot immediately respond to a request for information, because that's the nature of life. You're not always immediately available whenever that reasonable request for information comes in from your client. But what you can do is educate and utilize your staff to assist in discharging this communication duty. Now, that does not mean that you have your staff respond to the legal inquiry of the client. Rather, it is to explain to the client, just as it says here in the comment, when a response may be expected on the part of the client. And I think that when you look, that's one of the really interesting things about the rules of professional conduct. And that is that oftentimes when you read them, they actually guide the lawyer into steps that can be taken to help the lawyer meet their duties under the rules. So this, the next slide that I have coming up here is a case, obviously an older one now, but I suspect that even in this day and age, it still occurs on some level. Dividing phone message slips among non-lawyer staff and telling them to quote unquote handle it is not this. That is not using your staff to assist you in, for example, advising the client when a response may be expected. That's not that. So don't think that, once again, your duty of communication is satisfied by offloading basically the duty to, here certainly it was a non-legal support staff that was responsible for getting back to the individual. And if you read this case, there are all kinds of bad things. And this once again is an example. If you went out and read this case, it's an example of, if the lawyer had understood and diligently discharged, and I don't mean diligently inside the diligence rule, but faithfully discharged their duty of communication, then the lawyer wouldn't have done it the way the lawyer did it. But if you just, when you just hear communication, it doesn't mean anything unless you get into and really understand what the drafters and adopters of the rule are expecting from lawyers inside this duty of communication. The comments go on, and this is another interesting one, comment 5. So the last one was the lawyer can train the staff to assist the lawyer in meeting the lawyer's duty of communication within the structure of that comment 4. In comment 5, you'll note when the client is an organization or group, it is often impossible or inappropriate to inform every one of its members about its legal affairs. Ordinarily, the lawyer should address communications to the appropriate officials of the organization. And then there is, when, organization is client rule. Where many routine matters are involved, a system of limited or occasional reporting may be arranged with the client. So here's a situation where now you can look at your client and your area of practice and see how you can proactively educate your client in how you communicate with them that enables you to meet the duty of communication obligation. So, and let the client know. Well, let me back up a little bit, because I can see some lawyers out there saying, well, I know what I'll do. I'll put some boilerplate language in my fee agreement that says this, I'm going to communicate and then I'm okay. Wrong. No, that's not it. Because however you end up then doing it must also equal the, the consult, the respond, the other elements, the inform, those other elements right there, even if there is quote unquote an agreement with the client that this will equal communication. You can have something in, and we'll see this in a moment. You can have a phrase in your fee agreement that client consents to this form of communication. Well, okay. One, it's probably not consent if it's boilerplate language in a fee agreement. Probably not. Let's just say it isn't. It's not consent. Don't even think that it is. And then 2, if it isn't communication, calling it communication doesn't make a communication. That's another thing that lawyers do a lot. They'll drop buzzwords or phrases into their boilerplate, and then when things go sideways, they'll rely on those buzzwords and say, but I did it. Well, no, you didn't, because the underlying conduct didn't meet the buzzword standards. Let's see. Withholding information. Obviously, this is a very fact-specific issue in terms of communication. A lawyer may not withhold information to serve the lawyer's own interest or convenience or the interest or convenience of another person. But in some other circumstances, it may be that you see just above that in comment 6, it may be appropriate under the duty of communication rule to withhold information. So, like I said, that can be a very specific inquiry that is going to be determined by the discrete facts of the circumstances. But beyond that, it's possible, but it's a pretty high bar still to meet anyway. I would tell you, just in my experience in reading a lot of cases where that is where the withholding is the issue, the withholding of the information is the issue. All right. So this Missouri informal opinion from 2020 is kind of an interesting, it brings in to the fact pattern a lot of interesting issues. So the question is, may attorney comply with a protective order or participate in a settlement agreement requiring return or destruction of documents produced during discovery? So the first aspect of the answer from the Legal Ethics Counsel's office in Missouri deals essentially with the lawyer's duty, to return the file to the client, because the file belongs to the client from cover to cover. And oh, by the way, there's a new, just so you know, there's a new ethics opinion that reiterates a previous ethics opinion. That's one of the things that I see a lot now. The opinions just cycle through, kind of like, oh, I'm going to ask the question again. And the question that was recycled this time is, are emails part of the client file? Yes, emails are part of the client file. So if you have a stack of paper that is the client file, and then you have all of these electronic email communications with the client, and you want to reproduce, or the client asks for the file, and so you're going to give them the original file of paper because that's what the client is entitled to. If you want to keep a copy, you can keep one for your own convenience at your own expense, but you can give them the paper file, but you have to reproduce into paper or some other format when you give the file to the client, those email communications. And that also pertains to texts or any other electronic communications that you have with the client. That's part of the file, and it's part of what has to go to the client if the lawyer, either as a matter of course, gives the file to the client, because some lawyers will do that just as part of their standard procedures, or if the client requests the file at the conclusion or even during the middle of the representation, that becomes the duty. Let's see. So then we move on from there. The answer continues, first of all, with the idea of a protective order. So in the event that a client refuses to grant informed consent confirmed in writing to the attorneys handling the file documents in accordance with a protective order. So the protective order comes down and the client says, I'm not going to do it that way. I'm not going to give up some, whatever it was that was obtained during discovery, for example, or that's covered by the protective order. The attorney should first seek to modify the order. If the attorney can do so in compliance with Rule 3.1, meritorious claims and contentions, you have to meet that. If that's unsuccessful, then the attorney is permitted by 4-115D, which is the basic property rule, otherwise permitted by law, all right, where the lawyer can withhold something if otherwise permitted by law, some part of the file. And 4-116D, surrendering papers and property to which the client is entitled, which comes at the conclusion, that's the termination or withdrawal rule. Under 4-3.4C, the lawyer shall not knowingly disobey an obligation under the rules of a tribunal, except for an open refusal based on an assertion that no valid obligation exists. So be careful with that one. The attorney must deliver to the client the remainder of the file and so forth under 4-1.22, which is the file retention rule, which you're welcome. I won't tell you everybody involved in why that rule is in Missouri and why it is such a good rule, and who got it there for you, except to say that there were some people that are present in this conversation that pushed that forward. A lawyer, under the idea of settlements, a lawyer is to abide by a client's decision whether to accept an offer. Obviously, the lawyer is prohibited from participating in a settlement agreement restricting the lawyer's right to practice. So this can be a tricky, obviously, situation in the circumstances of a settlement that requires the lawyer to do something in order to meet the settlement, which may then also be a restriction on the right to practice in the future. If the attorney obtains the client's informed consent, once again confirmed in writing, to destroy portions of the file, sometimes that can be part of the settlement agreement, for example, or obtain the client's agreement to return to another party portions of the file, then the attorney may participate in the settlement as long as you don't run back onto that restricting the lawyer's right to practice. You see on the left-hand side of the screen there on this slide, the Tennessee opinion, for example, that addresses the issue of if it gets to that point of restricting the lawyer's right to practice, for example, by representing other clients, then the first lawyer is not permitted to participate in the offering, or the offering lawyer is not permitted to participate in the offering, and the accepting lawyer is not permitted to accept it, because it would be assisting in a rules violation on the offering lawyer's part, and then an actual rules violation on the accepting lawyer's part. Now, this is the terminology section material on, and we're getting now to this idea of informed consent. So here we go. Informed consent denotes the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. So then under that particular definition, that terminology section, there are many, 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 many comments addressing informed consent. But just look at that definition. A course of conduct after the lawyer has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. So if you think you're getting your client, and by the way, we're going to see here in just a moment, there is no consent without informed. So, you know, when I was talking earlier about lawyers' fee agreements, and here's the reason that I have the issue with them that I do. I've seen so many over the years where the lawyer just takes the salt and pepper approach to getting consent. I'm going to throw that in here. We're going to consent all over the place inside this boilerplate piece of paper. And then we're going to say, I have consent. Or we're going to say lawyer consent, or the client consents to this, that, or the other. Unless the lawyer communicates adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct, it isn't consent. If you have the word consent anywhere in your fee agreement, or you have the word acknowledge, or you have anything, dig up your thesaurus and look up every word that lawyers use to substitute for the word consent. If it isn't meeting that, you don't have it. And saying you do doesn't mean you do. That, you know, that's the point that I'm always trying to get across in our practice management program when I'm sitting there with a lawyer in his office and we're going through the documentation that the lawyer has, and she says, well, you know, I said, well, you do this. Why? Well, I have my client's consent right here in my fee agreement. I said, okay, let's pull that one out. Let's take a look at that. No, it's not consent. It's just the lawyer forcing some outcome on the client, and then putting the word consent in there and say, well, it's okay because I got consent. You know, I had a lawyer tell me one time, because we were having a conversation. I'd like to call it a conversation. It may have been a rant on my part about the disclaimer, the lawyer email disclaimer in Missouri, which is just, you know, a hilarious pile of goo in terms of what it says and why any lawyer would believe what it says. But there's no requirement that an email in Missouri have any sort of a disclaimer on it. I think that unless the disclaimer, because I see this all the time, you're receiving this because you've consented to receive that, you know, this email. I see that tagline put on there too. Okay, well, if you're dealing with a client, certainly, unless you got to that, you know, you haven't gotten consent. And the lawyer's duty in Missouri is not to have a stupid, worthless, meaningless, boilerplate piece of junk disclaimer on an email. That's not the lawyer's duty. The lawyer's duty in Missouri is to consult with the client about using email. And a stupid, boilerplate, worthless, meaningless disclaimer on an email doesn't do it. It's not required, and it doesn't meet the lawyer's obligations. Now, if a lawyer wants to put it on there, okay. But just, don't put it on there and believe that you've accomplished anything. You really haven't. You have accomplished nothing by having a disclaimer on your email in terms of your duties to your client. So, it takes more of a conversation. Well, I was having that conversation with a lawyer, and he said, well, we just put in our fee agreement that the client consents to being communicated with by email. Here at the such and such law firm, we communicate with our clients by email. By signing this agreement, the client consents to being communicated with by email. I mean, that's not consent. It's not even close to consent. So anyway, there's my conversation, my discussion about stupid, worthless, meaningless, don't do any good. Why are you bothering? Do what you're supposed to do. Email disclaimers. So then you get into comment 6 that talks about informed consent. And that red highlighted language that you see there really gets into the information that needs to be transmitted to the client in order for there to be informed consent. And it goes on. So just so you know, once again, this is stuff you have to read. That's another reason that I put it up, that I put all this information there. One, I've been accused in the past, well, you didn't put the whole thing up there, so we don't know that you're telling the truth. This is the rule. This is it. So okay, fine. I'll just put it all up there. You can see the whole thing. So I don't have that as a blocker when I'm talking about this topic. And then the other reason that I put it up there is so if you want to read it, you have the material where you can read it. Okay, you don't even have to go. By the way, if you go into your browser, whatever you use, and you type in Missouri Rules of Prof, you'll get Missouri Rules of Professional Conduct. You can go through and click on all of them. It's not any big secret about how you get to them. So you can do that online all the time. In fact, if you don't think what I'm saying is correct about any one of these rules, pull your phone up and type in Missouri Rules of Prof, and you can see the rule for yourself and the comment to the rule. 7, in general, a lawyer may not assume consent from a client or other person's silence. I've seen that not infrequently where a lawyer will, especially in a communication with a client, say, I'm going to withdraw from the representation and I'm going to assume that you consent to my withdrawal if you don't reply to this. I'm like, not unless you've gone through and given them reasonably adequate information about the matter. And probably you haven't, because as you see above, that takes quite a bit of information. All right, what else do we have here? Oh, one of the things that I did in putting the material together is I looked through all of the Missouri Rules of Professional Conduct for the word consent or the phrase informed consent, or you see there under 4-2.3 consents after consultation. If you see in, after these rules, in blocks, the letter C, that means that it's in the comment section, that informed consent or consent is referenced in the comment section as opposed to directly in the rule. But these rules require informed consent. So it's not just 1 or 2, it's a bunch of them, as you see there. The other thing I will also point out is one of the rules that's not listed here that requires a lot of informed consent to meet its standard, especially if there is a withdrawal prior to the natural conclusion of the representation. 4-116, withdrawal or termination of representation. If a lawyer violates 4-116, if you see the case being reported and there's discipline, there's going to be a 4-1.4 with it. Automatically, it just happens. There's no way that a lawyer can get into a 116 violation without having violated 1.4. So, and another thing, and I don't know why this is, but I've seen a consistent uptick in the number of cases where lawyers are disciplined for a 116 violation. And the withdrawal during the representation obviously is fraught with danger, all kinds of issues to delve in there. But even at the conclusion of the representation, when I started doing risk management at the bar plan, those many years ago, the big thing was fee agreement, engagement letter, explain all this stuff before you get another relationship with the client, blah, 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 blah. Fine, that's good. Okay, I guess as far as it goes. My experience now tells me the single most important standard letter a lawyer has that they can use in a best practices setting is the closing letter, the termination letter. That's the lawyer's last chance to put the lawyer's point of view regarding the representation and the attorney-client relationship in the best possible light without sounding completely self-serving. So take advantage of it. There ought to be however many man hours you have devoted to developing your fee agreement, 3 times that many hours need to be expended on developing your closing file, your case closing process. That's what my experience tells me now, having done this for a little while. Here's an interesting issue though, and it kind of makes me, it strikes me as a little bit ironic in terms of what I'm talking about, but right in the rules of professional conduct, guess who else consents conclusively? You. In 4-115A2, every lawyer practicing or practice in this jurisdiction as a condition thereof shall be conclusively deemed to have consented to the overdraft reporting and production requirements mandated by the regulations adopted by the advisory committee. So you've consented. How does it feel? Don't make your, don't let that surprise kind of thing happen with your client. Make sure that you're doing the informed consent standard. Now, where does this go in terms of kind of a real world application? Well, one of the things that a lawyer can do if there is, for example, a conflict of interest, is get a waiver with informed consent. All right. It says it right there in 4-1.7. Under 4-1.7, one of the things I want to point out is there are a number of comments addressing different aspects of getting informed consent and what equals a waiver and so forth. Comment 14 through 33 in 4-1.7. But here's a real live waiver. It was in a situation where a lawyer was going to represent a brother and sister who were both charged with a crime related to the same act, essentially. Now, I'm not going to read it here because I don't have enough time remaining. But what I would leave it to you to go back and read it and ask yourself, now that I've looked at the terminology section, where does this not meet it? But I will tell you, in my experience, this is a really, really good waiver from the perspective of a lot of attempts I've seen at waivers, and it didn't work. So the really good ones don't work either, oftentimes. So the Chief Disciplinary Counsel, when there was an ethics inquiry and a violation, and it got up to the Missouri Supreme Court, what you saw on the previous page didn't equal informed consent. It didn't advise the clients that they should consult with another attorney. It didn't disclose the different levels of culpability or group plea offers and how it creates conflicts. It didn't address the pitfalls that occur when with a joint representation, or address effects of loyalty, confidentiality, or attorney-client privilege. Another even more common example of this situation is where a lawyer has multiple clients in the same representation, just in a civil matter. Criminal, it gets really, really difficult, as you see here. And like I said, I'm not sure you could have waived yourself out of it, quite honestly. I'm not sure it was waivable. But in the civil setting, one of the things that's really important to make sure your clients know is if one of them stops rowing in the same and as the others, then there's a conflict. The lawyer's out representing all of them. And one of the things that's important then to explain is, well, what would some of those things be? For example, that's the, that, and what's the alternative? Think about what you have to say in order to equal that terminology informed consent language. So one of the things I did, first of all, you see my own warning and disclaimer there for what I'm about to show you. One of the things that I'm often asked for is, doesn't the bar plan have a form conflict of interest waiver form? No, we don't, because as you can imagine, there's no way that a form can meet the informed consent standard. It's impossible. So that means if you want to get a waiver, you have to actually do the work of getting your clients informed consent. A form will not do that. Now, like it says here, the consent portion is fairly easy. And so what I did was I actually just took the informed consent terminology language and dropped it into, this is where the client consents. Fine, that's easy. It's the informed part that creates the issue. And so just so you know, if you ever need something like this, one, you can review this, you can take a look at it. Give me a call. We can try to talk through some specific issues you may have if you want to try to get a waiver. But it becomes difficult to do. Now, when a lawyer wants to put or wants to use arbitration as a way of resolving disputes in the attorney-client relationship, oftentimes there will be an arbitration clause in a fee agreement. One of the things that this opinion from 99 says is, yes, a lawyer can do this. There's an ethics opinion that says that agreement can be in that clause can be in the fee agreement. That's permissible. However, look at what the opinion states. Notwithstanding the existence of a concurrent conflict of interest under paragraph A of 1.7, a lawyer may represent a client if the lawyer does the 4-1.7b requirements. What is this saying? This says that putting an arbitration clause in a fee agreement creates a conflict of interest. How does the lawyer get around it? The lawyer gets around it by getting the client's informed consent to that clause. And so now, well, okay, what equals that? And here's a case from, what is this? This is from now just 2 years ago, where that's exactly what the law firm was trying to do. And they put some information in their fee agreement. And what the court held was, sure, you may be, let's see, you may be telling them that it'll be submitted and finally determined and disputes arising it without limitation. You can put a lot of stuff in there, but are you still meeting the informed consent standard? And one of the things that the court noted a couple of different things here. One is that if the arbitration service, if there's one selected in the agreement or in the clause, the processes of the service have to meet the lawyer's ethical obligations to the client. So there's an issue to be aware of. Number two, as another issue, is it's possible that this agreement could be a violation of, in this instance, in New Jersey 1.8H1, in Missouri 4-1.8H, which is trying to prospectively limit the lawyer's malpractice exposure. And then the clause itself, or the conversation, in order to get informed consent, has to go into the advantages and the disadvantages of arbitrating a malpractice claim. Oh, by the way, I think in the hashtag #MeToo bill, it has effectively, as I understand it from a brief reading, it has effectively eliminated use of arbitration if it was agreed to in some sort of employment agreement. You can't, an abuse victim allegation party cannot be forced into arbitration if it was part of some sort of an employment agreement. So that kind of gives you a standard about a little bit, or maybe it illustrates how much has to be explained in order to meet that informed consent. And it isn't simply, as you see here, it's not just you won't have a right to a jury trial. That doesn't do it. I always think, one of the things is when you talk about, let's see, inside informed consent, reasonably available alternatives, one of the reasonably available alternatives is you don't hire us. Maybe that needs to be in there. I mean, if that's really, where you want to go, it has to be truthful. In other words, you can't put language into your fee agreement if you don't really mean it. So if you say, well, you have to, one of the reasonably available alternatives, you would have to secure counsel who's not us. But you have to really mean it. You can't, if the client says, well, I'm going to go somewhere else. Oh, well, we really didn't mean that. For heaven's sakes, don't say that. You have to really mean it. It has to be truthful. But nevertheless, that's one of the really available alternatives the client needs to be made aware of. Let's see, what else do we have? Oh, this is, the issue with the fee agreements. Once again, and I'm going to go until 5 till. So it looks like I have about a minute, and then I'm going to stop. Rob, just so you know, if there are any questions, feel free to jump in and let me know what they are. But here's, once again, language that the lawyer put into their fee agreement. Lots of stuff, but then, what kind of hung them up? You see there it is in bold. Therefore, it is agreed that client shall pay the attorney those monies necessary on a 30-day as billed basis to maintain the retainer at its original level. Okay, there was nothing wrong with the fee itself. That wasn't the problem. The problem morphed into, for the lawyer, the fact that the lawyer asked for the replenishment, but didn't provide the bills. And so, so the court said, two different things. One is there was a violation when the client asked for the billing and didn't receive it, right? But there was also a violation when the lawyer said to the client in the fee agreement, I'll send you a bill, and then the lawyer didn't do it. That in and of itself is its own standalone 4-1.4 communication violation. If you're going to bind yourself to something in your contract, you need to do it. And that concludes my presentation here this morning. Thank you very much for your time and attention. Rob, once again, thank you as always. And for your entire staff for their gracious consideration of herding all of the cats that are your speakers, this cat in particular. Thank you very much.
Chris, I had one question from
Sure.
our audience, and that is, without having a mediator involved, how is one side in a dispute assured that the opposing party is actually communicating settlement offers to their clients?
Okay, without a mediator, I'm not sure I understand the setup. Who's doing the communicating to whom?
So let's say a defense lawyer communicates to a plaintiff's lawyer an offer to settle a case.
Okay.
How can the defense be assured that that plaintiff's lawyer is actually communicating that offer?
Oh, I see.
Plaintiff? because they obviously have a duty to communicate. What can the opposing lawyer do to give them some comfort that that in fact is being communicated to the other side?
I am not aware of anything, any way to force like some sort of discovery or acknowledgement that it has been communicated definitively. I don't know. Now I understand, I think, what the issue is, and I'm not seeing a way under the rules, for example, or even under a discovery issue approach about how to achieve that.
The
So
only
that
thing,
I'm no help at all on that.
well, the only thought I have is if the defense lawyer in that example is communicating an offer, you could ask the plaintiff's lawyer, please confirm that you have communicated that to your client.
Yes. Now, one of the issues there is that before the plaintiff's lawyer, for example, confirmed it, the plaintiff's lawyer would have to have the clients, the plaintiffs, informed consent to reveal the fact that it has been confirmed, because that's confidential information.
Sure.
So that, you know, there would be a step in there. Now, let me just say, as part of the, I use a quiz question this year that talks about email communication and CCing parties in email communication between the lawyers. And I would point out that New Jersey has, if you take, you know, if you attend my program later this spring, you'll get this one right. New Jersey has an ethics opinion that says in the email setting, it's if like in this situation, if plaintiff's counsel CC'd their client into a communication to defense counsel and defense counsel replied all, in New Jersey, that would not be an ethics violation. But in 5 or 6 other states, it would be, including Illinois. And in Missouri, it has not been addressed. So, but you'd have to read the New Jersey opinion and how they parsed through the environments where the communication was taking place. But you know, if Missouri, for example, if a lawyer that had this situation asked the question of the legal ethics counsel's office, maybe there could be an informal ethics opinion issued that might fall in with the verboten states that have already addressed this, or the fairly recent, I think it's like a year or 2 years old, New Jersey opinion that says, if you get into the back and forth and one of the lawyers has included their client, it's okay to CC the client in a reply. You know, we might have a little bit more direction also, because then defense counsel in this scenario would be assured that the client actually was seeing it because it was part of the email. However, you know, beyond that, what I would say right now is don't do that. Don't do that. Don't do that unless you're domiciled in New Jersey. Because it's an open, like I said, it's an open question and the majority of opinions have come down against it.
Chris, thank you. Thank you for the presentation. As always, very informative. It's a great reminder to all of us who are in practice, the things that we have to do and the hoops we need to jump through. And obviously as cases come up and informal opinions come up, to stay on top of that. So thanks so much again.
You're very welcome again. Yeah.
Yeah.
And thanks again for having me.
Our pleasure. Folks, we're going to take 5 minutes to switch out the program materials and then start on our last program. I have 2 minutes after, so we'll start at 7 after 11. Thanks. Folks, why don't we get started with our last program? Before we do, just a reminder of the 2 upcoming best practice programs, April 22 in the morning and June 22 as an all-day program. Last year's all-day in June was so successful, we've been asked to do that again and look forward to presenting some great programs. Also, I want to thank Kelly Spiller, who is the key staff person here at USA&M that puts this together, who communicates with each of you. She will be sending an email to all of you with a link to the evaluation form, and those who were seeking Illinois credit, she'll forward a form to you as well. And we'll get started with our last program. Mike Young has really given of his time. I think it was 2 years ago at the beginning of the pandemic when everyone was dusting off their insurance policies, Mike, and reading definitions and reading exclusions. And you did a terrific program for us then. Mike is a partner at Hepler Broom. His primary focus is in the insurance area, insurance coverage, bad faith claims, et cetera, representing insurance companies, Missouri, Illinois, and various complex matters. Many of you who frequent LinkedIn may see Mike's daily posts that are both informative and sometimes entertaining. He's also very involved with the CLM, the Claims Management Litigation Alliance, as well as the Missouri Organization of Defense Lawyers, a proud graduate of WashU and St. Louis U Law School. We are fortunate to have him presenting on this important topic, dealing with insurance issues, both Missouri, Illinois, and bad faith and what's been going on, because I know there's always a new case coming down the pike. Mike, thanks very much.
Thanks, Rob, for that introduction. You forgot to mention that since I do insurance coverage, that has got me the nickname Mr. Excitement. I'll put that in the bio next time, but I do appreciate you inviting me back to speak on some basics on Missouri and Illinois insurance law and bad faith. And if folks have questions, just type them for Rob, and happy to try to answer these as best as I can as we go through it. There's just so much going on in Missouri, some things going on in Illinois, but Missouri is really, we're especially on the liability coverage side, seeing a lot going on. Okay, so you can't possibly cover it all in 50 minutes or so. So what I thought I would talk about are basically these three things. Settlement demands in Missouri, particularly on bodily injury cases, the new 537065 that we have in the state, and then Illinois, hopefully we get time for it. We're going to talk about this new case that came out that addressed what would be covered under liability policy for the so-called BIPA statute, which is the biometric data statute. So, but before we get to that, we'll start with Missouri and settlement demands. And in 2017, the legislature passed this statute that said if it's a bodily injury, wrongful death, or personal injury case, statute doesn't define personal injury. But for BI wrongful death cases, if you want to make a settlement demand that's a time limited demand, you have to do certain things. And you have to, as it says here on the screen, put the location of the loss, the claim number, the injuries, tell the insurance company exactly how much you want. You have to provide the carrier 90 days from the date it's received in order for them to respond to the settlement demand. You have to give authorizations, not just for healthcare providers, but also for employers too. So it's a pretty, involved sort of statute, what you have to provide in order to make a settlement demand on BI wrongful death and personal injury cases. The whole if the demand does not comply with all the particulars of the statute says that the insurance company shall not be considered to have a reasonable opportunity to settle, which is basically the trigger for bad faith cases. The carrier has to have a reasonable opportunity to settle in order for them to have an obligation to settle a case in good faith. And if you don't comply with the statute, you're out. The interesting argument that we have seen, though, over the last several years is that this statute says that it applies to time-limited demands, right? And as we have here on the screen, it says a time limit demand is an offer to settle any claim for, BI, et cetera, but it has to be accepted within as you see in the bottom there, a specified period of time. And the argument that the plaintiff's bar has raised, which is an interesting one, is, well, if I issue a settlement demand and it doesn't have a deadline on it, the statute doesn't apply. And so what we've been seeing, are settlement demands that, have literally no deadline. We hereby demand that XYZ insurance company pay the policy limit of $50,000, no deadline. Or it'll say, we'll keep this open for a reasonable amount of time. Or here's the settlement demand, but we won't keep it open forever. Various ways of, saying there's no deadline in an effort to get around, you can see my bias there for the carriers, in an effort to get around the statute and have it not apply. And I thought it was pretty interesting little argument, and we were seeing so many of these demands, and frankly, we're still seeing them today. Then this case came down last summer. This is the Jamison versus Still case. What happened in this one is that there was a settlement demand that was made. The insurance company rejected it a couple different times. But then eventually within the 90-day deadline set forth in the statute, they did accept the settlement demand and took the position, we have a deal. And the plaintiff's counsel said, well, wait a second, you've rejected my demand twice. I never opened it up again. You can't just come around on the third or fourth time and say, okay, we'll pay it. It's already been rejected. There isn't an open demand. And so the carrier in this one raised the argument that, well, under this statute, a reasonable opportunity to settle means 90 days. So long as we eventually settle it within the 90 days, then we have a settlement. And the Eastern District of Missouri did not buy that argument and said, no, once you reject it or make a counter offer, which is deemed a rejection of the offer, then the offer is dead. You can't accept an offer which isn't open anymore. So, that was maybe not that controversial a decision, but what was interesting though, is that the court went on to explain its rationale. And here's the key piece. In this decision, the appellate court said, we observe that 53705A, that's the settlement demand statute, provides clarity with respect to what shall be considered a reasonable opportunity to settle in a later bad faith refusal to settle suit against the insurer by codifying the requirement of the demand. Okay. And as you can see towards the top, it says one of those 8 requirements is that the demand remain open for at least 90 days. So through the course of this case where the carrier was raising some other argument, the appellate court just comes right out and says settlement demands, in my view, have to comply with the statute, which means they have to be left open for 90 days. And so I think, this case, in my view, sort of rejects this idea that if you keep a demand, make a demand and don't have a deadline on it, that somehow that can get you around the requirement of the statute. I will point out, though, that this case, the Missouri Supreme Court has accepted transfer of it. And so the status of this decision as of today, I think it's good law, but the Missouri Supreme Court is going to take this case, and this is definitely one to watch. If you handle BI wrongful death cases and settlement demands, what is the Supreme Court going to do with this? Are they going to issue a similar, are they going to affirm, are they going to reverse? Are they going to issue similar instruction to us as to what you have to do in order to make a settlement demand? So this is definitely one to put on the watch list. So that brings us to the next big Missouri topic. And this is, again, in the BI wrongful death personal injury world, this is really what everyone's talking about, is the new 537065. And what does it do? What does it change? How is this going to play out? And so I think in order to understand the new changes, and by the way, this statute became effective August 28 of 2021. So essentially, this is the law as we're sitting here today on most cases that we'll be handling. What does the statute do? I think in order to understand the statute and its changes, you have to have an idea of what came before it. Okay. And so you have to kind of do Missouri insurance law kind of 101 is I call it. And, and for the folks in the conference here that know this stuff, I apologize if it gets too basic, but I really think you can't understand what's going on here without kind of running through the basics. Okay. The statute 537.065 obviously applies to liability cases. In Missouri, when an insurance company gets a petition and they're trying to figure out is there coverage for this, right? The key initial question that they have to decide is, do we, the carrier, have a duty to defend the suit, right? Do the allegations of the petition and in Missouri, the extrinsic evidence reasonably available to the carrier, does it suggest that the claim could be covered by the policy? If it does, then the insurance company has a duty to defend the lawsuit, the whole thing, okay? Not just the parts they think are covered. You got to defend the whole shooting match. So it's not always clear, right? I mean, if you have a case on point that has looked at your facts and your exclusion or whatever and says that it's covered or not covered, that's easy. But many times, is a trial judge in St. Louis County told me, you don't know what's covered until a judge tells you what's covered. And so it's not always easy sometimes. And so when the carrier gets these, they have to decide what we're going to do. They basically have three options, and here they are. The first thing they could do is defend the lawsuit without reservation of rights. Okay. If they defend the lawsuit without reservation, they've essentially given up their coverage defenses. They have to defend and indemnify the policy limit. The second thing that they could do is decline coverage. Just say, we're not going to provide any defense at all. And there's consequences to that. The third thing that they can do is they can defend under reservation of rights. And we've seen this. This is where the insurance company says, we will defend you today, insured, but we don't necessarily agree that we will indemnify you against the judgment or settlement. Or we'll defend you today, but maybe we'll reserve the right to pull the defense later, depending on how the evidence plays out, et cetera. That's the third thing you can do, is you can defend under reservation. If the insurance company defends under reservation and it's accepted by the insured, then they've preserved their coverage defenses and they can raise them at a later time. But the insured has to accept that defense, and they can accept it by, saying I accept, but they can also accept it by conduct, going along with the defense provided by the carrier. However, Missouri is a little unique, I think, in terms of state's insurance law, in that we allow in Missouri insureds to reject the reservation of rights. Can just tell the carrier, no, I don't want your defense under reservation. I want a full defense without reservation, pay for this claim subject to the limits. And here's what happens. When the insured does that, now the ball falls back into the insurance company's court. And they essentially have three options. The first one is they can withdraw the reservation of rights. If they do that, they've bought the lawsuit subject to the limits. They've given up their coverage defenses. Or they could do number two or number three. They could refuse to withdraw the reservation of rights, or they can file a DEC action. If they do one of those last two, refuse to withdraw it or file a DEC action after the reservation's been rejected, that's deemed a denial of coverage. So we go back here, it's as if they decline coverage from the get-go. Okay. Why does this matter? All this matters because of 537.065. The original statute, as it was written in 1955, here it was. It essentially said, if you have a bodily injury or death case, note it doesn't say personal injury, it just says BI or death. If you have a BI or death case, the insured and the plaintiff can agree that if a judgment is entered against the insured tortfeasor, then the plaintiff can agree that they will only try to collect that judgment against the insurance company. And so what we saw and so it's essentially like a covenant not to collect statute. Over time, though, what happened is that the 065 agreements entered under the statute got much more creative, right? And you had insureds agree not to put on a defense, not to show up at trial, to admit certain facts, transfer cases from what are perceived to be conservative jurisdictions to not so conservative jurisdictions. And we were having judgments that were being entered in certain courts. You know, the insurance industry refers to these as consent judgments. I know judges and plaintiffs and insureds disagree with that. They feel like, you know, there was some evidence put on and the court just ruled on it. But there, I think everyone would kind of admit they weren't full-blown trials. They were more like hearings like you would see on a default motion. And what happened then is we would have judgments that would have findings of fact that showed that what the carrier thought was an uncovered claim suddenly became covered. You know, negligent punching in the face. What was one of the hypos that, you know, the industry always talked about, and we always kind of laughed that was extreme. But there was a recent case where there was an 065 agreement and a judgment entered where the court found that the defendant, who was criminally convicted of stabbing someone, the finding there was that the insured negligently stabbed the plaintiff in the back as he was running away. Okay, so these are, you get these facts that are you know, relevant to coverage, and you know, there's some issue as to whether or not those are enforceable against the carrier anyway, but that's what was being done. And you also had judgment amounts that, you know, were proposed by plaintiff's counsel, not opposed by anyone. And so from the industry perspective, you had judgments that were entered that were much larger than what they thought would happen if the case had otherwise gone to trial. We also saw something of a development recently too, where the hearing to approve, you know, to enter the judgment wasn't even actually done in a trial court. We saw these private arbitrations that were going on, you know, and you know, plaintiffs and insureds were having a private arbitrator determine liability, damages, you know, findings of fact relevant to coverage, and then going to the circuit court and having judgments entered in accordance with those arbitration awards. So this sort of process is, you know, not completely unique to Missouri, but, you know, definitely puts Missouri on the list of states that frankly scared insurance companies. And, you know, the question was always under the old statute, the 59 version, when do you get to do one of these deals, right? And here's what Missouri said on that. If the insurance company declined coverage, the plaintiff and the insured could definitely do an 065 agreement, okay? So again, if the insurance company refused to provide a defense, you could do an 065. If they reserve rights and they were rejected and the carrier refused to pull the reservation, that was deemed a denial, right? And you could do an 065 then as well. The second way that you could do an 065 agreement is if the insurance company refused to settle within the policy limits and that refusal to settle was deemed to be in bad faith. And, you know, before the statute was changed in 17, we used to see a lot of these, you know, where we would see settlement demands, if the carrier didn't pay it, plaintiffs and insureds were proceeding to do 065 agreements, and we were off to the races. The third way that some people felt, I don't, but some people felt you could do an 065 is simply if the insurance company reserved rights. No rejection, just did a reservation of rights. A lot of folks felt like you could do an 065 agreement. We didn't have a lot of real clear case law on that. So that was always really the real question, you know. So if the carrier reserves rights, can plaintiffs and insureds proceed to do one of these 065 agreements? So the statute was amended. This is not the current version. This was amended in 2017, some, you know, 4.5 years ago, I guess, if I did the math right on that. And here's what they did. They did a few things. They said, you know, they took the old 065 statute, and you can see it still says you can do one of these if it's a bodily injury or death case, but they also now said you can do it if it's a personal injury case. Unfortunately, the statute doesn't define what is meant by personal injury, so that was up in the air. The other thing they did, and you can see this in the language in bold too, is they tried to clarify, you know, when you can do an 065, and particularly if we just reserve rights, the carriers, if they just reserve rights, can you do an 065? They said you can now do an 065 agreement if the carrier has the opportunity to defend the tortfeasor without reservation, but refuses to do so. Now, I know the legislature, when they wrote this, felt like what they were saying is this language means you have to have a denial or an ROR that's been rejected and the carrier has refused to pull the reservation. But folks were arguing no, simply reserving rights may meet the standard as well. So they tried to clarify that point and maybe had, I think, some mixed success on that. The big thing, though, that the statute did, which was a complete change from anything that we had done in Missouri before, and frankly, not a lot of other states do this as much as you might think, is that they said, here's the statute, if a plaintiff and an insured do an agreement under 537065, they have to provide the insurance company with written notice of the contract, and they will have 30 days, this is the carrier, after the receipt of the notice to intervene as a matter of right in any pending lawsuit. And you see pending in bold and italicized. They have a right to intervene in any pending lawsuit involving the claim for damages, so long as, you know, if they do an 065, the insured tells the insurance company about it, they get a copy of it, then the clock starts. The carrier has 30 days to move to intervene into any pending lawsuit. And the thinking here, I think, of the legislature when they put this together is they had some notion that this would now be like UM or UIM cases, okay? Particularly you see this in UIM, if you have an underinsured motorist carrier and they see and they have noticed that there's a lawsuit pending against the underinsured motorist who has liability coverage, is not enough. If they know that suit is pending against that underinsured driver, the UIM carrier can intervene into the case and litigate liability and damages. And if they don't intervene, if they had notice of the suit, then they're bound, you know, by any findings of fact on liability and damages that are entered. So like we already in these, you know, these UIM cases had this notion that the carrier can intervene and litigate liability and damages. That's what the legislature thought they were going to bring to liability cases. Okay, we're not going to stop those, you know, plaintiffs and insureds from doing 065 agreements. The insured should have a right to protect themselves, but we're going to, in their view, balance it a little bit and let the carrier jump in and, you know, prevent what the industry felt were these so-called consent judgments. You know, let us have a lawyer at the hearing so we can litigate liability, damages, and findings of fact, perhaps that would be relevant to coverage. Okay, that was the thinking. It didn't, to put it mildly, go exactly to plan. Okay, so we had some different issues. I said earlier, you know, the language, could you just intervene? Could you do an 065 if there's just a reservation? Was there a reasonable opportunity to settle or opportunity to provide a defense without reservation and refuse to do so? You know, that was up in the air if a mere reservation would do it until I think the Stacy versus Barr plan came out in the 2021. This was a case where the insured and the carrier had a fight over how many policy limits were available. And the insured took the position that the carrier saying that there was only one limit, and the limit is X, that was a reservation of rights, which the insured rejected. The carrier wouldn't walk away from its limit position, and so they did a 065 agreement. One of the holdings in the case, which was interesting, is that the appellate court said that, you know, the carrier asserting its policy limit is not a reservation of rights. Okay, that's sort of a majority rule. Most states do that. We didn't have that holding though until Stacy versus Barr plan. But because it wasn't a reservation of rights, that meant the carrier was providing a defense without reservation, again, subject to the policy limit. So when the insured and the plaintiff did their 065 agreement, they did it even though there was no refusal to provide coverage. And the interesting thing is, so the appellate court says at the top there, because the evidence shows that the Barr plan, which was the carrier, did not unjustifiably refuse to provide WIT the insured coverage under the policy, WIT had no authority to enter into the section 5375 agreement with the Stacy's, the plaintiffs, without the Barr plan's consent. So this case, I think, really suggested you need to have a denial. You know, there has to be an unjustifiable refusal to provide coverage. So this, I think, made it very difficult to raise the argument, well, if there's an ROR, I can do an 065. It's like, no, you have to have a denial in some fashion. Timing, you know, as we back up, the timing thing is that once the agreement was entered, you have to tell the insurance company, and the carrier then has 30 days to intervene in any pending lawsuit. We saw, and these are the 4 big cases where plaintiffs bar with insureds really ingeniously developed some theories to get around and defeat the carrier's right to intervene in cases, okay? And how do they do it? They did it with different timing mechanisms, okay? It says you have 30 days to intervene in any pending lawsuit. The appellate court in these cases took that pending lawsuit language in the statute incredibly literally and said, once you get the 065 agreement, you have 30 days to intervene in any pending lawsuit. If there is no lawsuit pending in that 30-day window, too bad. There's nothing to intervene in, okay? And so you by, you know, timing how the 065 agreement was provided to the carrier or doing things with the underlying lawsuit could particularly stop the insurance company from intervening. So like, for example, Britt versus Otto, this was a case where there was no 065 agreement. They told the carrier about it, but there was no lawsuit pending. The parties waited 30 days and then filed a lawsuit. The insurance company tried to intervene. The appellate court said there is no pending lawsuit within that 30-day window. And the carrier said, well, exactly, you know, so how can we intervene in something that doesn't exist? And the appellate court basically said, that's your problem, insurance company. You have 30 days to intervene in any pending lawsuit. The Aguilar case was a case where there was a pending lawsuit. The insurance company did get notice of the 065 agreement. I think they actually did intervene into that one. And then the plaintiffs dismissed the case without prejudice, which obviously in Missouri you have a right to do, and you get one free refile. So the suit was there. They dismissed it without prejudice, waited 30 days from when the carrier got notice of the 065 and refiled it. And then the carrier then tried to intervene again. And the appellate court said, no. On the second try, when you tried to intervene, yes, there's a pending lawsuit, but it wasn't pending within 30 days of when you got notice of the agreement. Okay. And so, you know, we're effectively able to cut out the carrier from intervening. The last two there, the Nye case and the Loveland case, these are cases that use the different timing mechanism. Okay. You'll see here that it says that the insurance company shall be provided with notice of the agreement. It doesn't say when they have to be given notice of the agreement. There's another part of the statute that says they have to be given notice no later than 30 days or something like that before judgment is entered. But before that, there's no like requirement on when you have to provide actual notice of the agreement. So what they did in the Knight case, and I think a little bit in the Loveland case too, is they did an 065 agreement, the plaintiff and the insured, but they didn't tell the carrier about it immediately. I think it was State Farm maybe. And they did a private arbitration and waited 30 days and then told the insurance company about the 065 agreement, filed suit to get the arbitration entered in accordance with the statute. And the insurance company intervened within those 30 days. They thought everything was going good. But then the appellate court said, no, the findings of the arbitration award have already been made, right? And when you intervene into cases, you have to take the case as it is. And so when they intervened into the lawsuit, all they could do is try to argue, as most cases when there's an arbitration award, you can only try to set aside an arbitration award for basically fraud or collusion and so forth. And we're not able to relitigate all the findings of fact and liability and damages. So again, Knight and Loveland to a certain extent are cases where they didn't use the timing of the lawsuit against the carrier. They held the agreement. It was the timing of providing the agreement to the insurance company that, because the statute didn't have a deadline on it, they were able to do an in run around the statute. At least that's how the industry saw it. So if plaintiffs and insureds, were sophisticated, knew these strategies, they could, given the right set of facts and procedural posture, do a whole lot to effectively defeat the carrier's ability to intervene and try to litigate liability and damages. One of the arguments that was raised in the Knight case is, well, wait a second. These arbitrations are unfair. We're not there. Sometimes we are invited, but we don't want to participate. Maybe we do, maybe we don't. But that these arbitrations are unfair, that this is not like a legit court proceeding. How in the world could this be proper? And the Knight court in the Western District said, no, this is just fine. And here's the quote. They said, we can't find that the arbitration proceeding, at least in that case, employed methods akin to fraud or what was so lacking in adversity that the award was rendered void, when the Supreme Court has held that the results of a bench trial conducted under similar procedures was presumptively reasonable and cannot be challenged on the merits. So I don't know if Knight case says that all arbitrations were valid. I think you'd have to look at them case by case, but just the mere fact that it was a private arbitration, the appellate court in Knight said that was okay. And so this intervention right that everyone was so fired up about 4.5 years ago was looking, almost like a right on paper only. We also had issues of, let's say the insurance company did intervene in a timely basis and there was a lawsuit and it wasn't dismissed. Then the other issue is, well, what does the carrier get to do once they're there? Okay. Because if you look at the statute, it just says they have a right to intervene as a matter of right in any pending lawsuit involving the claim for damages. The statute doesn't say what the carrier gets to do once they're there, right? And so we had cases all across the state, county by county, judge by judge, taking different views. Does the carrier actually get to litigate liability and damages, findings of fact? Can they just assert coverage? There were some trial judges that said the insurance company doesn't get to do anything. You get to intervene, not just sit there and watch. There was one case that went so far, I believe in St. Louis County, where the trial judge said that the carrier doesn't get to do anything. That judge left the bench, a new judge was assigned to the case, and then that judge took a completely different view and said, no, the insurance company does get to litigate liability and damages. So it was truly all over the place. We had some commentary here from this case from the Supreme Court involving a case out of the county that suggested that the insurance company, may not be able to do anything. That quote there at the bottom was actually a concurrence. It's not in the majority opinion, but that was the closest where the court was like wondering, hey, does the insurance company really get to do anything? The issue was sort of settled, I think, last summer in a case out of the Western District where the insurance company intervened into the suit. It was timely and wanted to take the plaintiff's deposition. And the trial judge refused to grant a motion to compel to allow that deposition and said, no, we're not going to let you take the plaintiff's depo. The appellate court said that was error because the amount of the plaintiff's damages were still at issue in the case. They said, no, the insurance company, they have the right to litigate at least this damage issue. And so this case kind of suggested, well, maybe the carrier does get to do something if the case was there. Now, what was interesting about this one a little bit is that the appellate court said, yeah, it was error not to allow the insurance company to depose the plaintiff on damages, but they said it was not reversible error because the insurance company was able to get the plaintiff's interrogatory answers. So that one was a little interesting, but at least sort of gave us the idea that you could do something. So this is all leading up to what is our current statute. This is was changed in last summer, August 28 of 2021, and it did a number of things. Okay. One of the things that it did is it sort of did away with these arbitration proceedings and said, if, plaintiffs and insureds want to do arbitration deals, that's fine, but unless the insurance company has agreed in writing to them that none of those findings are binding on the carrier. So it sort of got rid of this private arbitration in run that we saw in the Knight case. They also modified 065 itself, the statute, in a couple different ways. The first one is the question, when do you get to do an 065? They actually came out right and explicitly said, here's when. If the insurer has refused to withdraw reservation rights or decline coverage, which is what they always meant. Now they just came out and said it. So simply reserving rights without a rejection, according to this, you can't do an 065 agreement. They kept the intervention thing. There was some debate, do we even want to keep this intervention thing going? So now it's still the same thing. When the carrier gets notice of the 065, they still have 30 days to intervene into the suit. But what the statute does now that it didn't before is say when you have to give the insurance company notice. Okay. And this is sort of like the eye exam portion of the presentation here. But now they tried to address the Brit and the Knight situations and try to say, look, whether there's a suit pending or whether not, or if it's dismissed and refiled or whatever the case may be, we want to make sure that the insurance company gets notice of the agreement and then has 30 days to intervene. And each one of these pieces of the statute is really a response to those 3 or 4 cases I had on the screen earlier. So if there is a lawsuit pending at the time of the agreement, the carrier gets 30 days. You have to give the carrier notice of the agreement within 30 days, which then triggers the carrier's right to intervene. If the second piece there, if there's a claim against the tortfeasor, but it is dismissed, then when it's refiled, the insured has to tell the insured carrier about the 065 agreement within 30 days, and then they have the right to intervene. And if there's no action pending, which is the bottom one there, then when the suit is eventually filed, then you have to tell the carrier within 30 days, and then they get to intervene. So it's a lot, and it's super complicated, but really the only way you can understand it is to know what came before, because this statute is these revisions is a complete response to those other cases that allowed in runs around it. There was also some update in the new 065 statute as to, well, what does the insurance company get to do once they're there? Because we had these different debates. Do we just sit there? Do we get to just do coverage? Do we get to do liability and damages? Now the new statute says that the intervener, which is the insurance company, shall have all rights afforded to defendants under the Missouri Rules of Civil Procedure and reasonable and sufficient time to meaningfully assert its position. That's the key language. Meaningfully assert its position, including but not limited to the right and time to conduct discovery, right and time to engage in motion practice, and the right to a trial by jury and sufficient time to prepare for trial. So the issue then is, what does it mean to allow the carrier to meaningfully assert its position? That is what we'll probably be litigating for the next 2 or 3 years until we get a court to outright tell us the legislature intended that it means the insurance company gets to litigate liability damages, findings of fact relevant to coverage. We'll see if the courts interpret that language in that fashion. The other thing, the other amendments to the 065, I mean, there's just all kinds of little pieces they add to it too. And you can see some bullet points here. The new 065 statute says that all the terms of the agreement have to be in writing, so if there were any side deals or assignments or, splitting up a fee, all that's supposed to now be in writing in the 065. Another thing that they added is that the 065 agreement is now admissible in any action against the insurance company for bad faith. One of the arguments that was raised by the plaintiff and insured bar is, well, we get to do these agreements, and when the bad faith case is filed, the jury doesn't get to hear it. Obviously, because once there's a judgment that's entered, the suggestion would be that the insured would have to pay for it. The carrier wanted so badly in these cases to put the 065 agreement in front of the jury and say, look, yes, there's this huge judgment, but you don't have to feel bad for the insurer. They're not going to have to pay for anything because they're completely protected. And that was a fight that went on all over the state. And you can see now that the statute says that those agreements are supposed to come in. Then the third piece was the statute now says that the insurance company's exercising of its rights under the statute shall not be considered bad faith. One argument that was raised a lot was under the old statute, the 17 version, is that when the carrier intervened into the suit, the insured would argue you've just made the lawsuit worse because you put insurance in front of the jury or the trial court, and that is somehow going to prejudice me. You're taking positions that are undercutting my so-called defense of the case, all the conflict stuff, and so some really interesting ethical issues there. The legislature now has said, no, if the carrier intervenes, there shouldn't be any suggestion that somehow that's bad or that they are, acting inappropriately or in bad faith. So that is the new 065. And if anyone has any questions on that, I'd be happy to take any of those. I don't know, Rob, did we have any questions so far on all that?
So there was one question, it didn't cover the 065 issues, Mike, but I wanted to pass this along. The question is, if the medical authorization does not allow for the disclosure of medical bills, both the paid and unpaid, is that compliant with the statute? Insurance carriers want to be able to determine the full amount of billing and how much was paid in order to evaluate their exposure.
Yeah, honestly, I haven't seen that issue in terms of the statute before. I don't think there's a case on that. Just pulling up that language again, I mean, it just says, list the names of the healthcare providers who provided treatment or evaluation of claim or decedent for injuries suffered from the date of the injury, and HIPAA-compliant written authorizations sufficient to allow the liability insurer to obtain such records from the healthcare providers listed. So I think, the carrier argument would be, we should get everything, right? That is, relevant and HIPAA compliant. So getting the paid and the unpaid, seeing those full bills, that is, part of the healthcare record there. Now, is there a case that says that? I'm not aware of that, but that would, I think that would be the argument on that.
Well, and obviously that's an issue when any defendant or carrier is looking at exposure, they know that the billed and then the paid payable values factor into how they evaluate the case. Now, it may be moot because you may have a plaintiff not putting the bills in, which I think is a current trend.
Right. That's exactly right. That's interesting to see that issue teed up in terms of the settlement demand statute.
Mm-hmm.
I promise, I know we're coming up maybe on 5 minutes left. I didn't forget about Illinois. Illinois, we don't have, over there some dramatic changing yet of how we handle settlement demands and intervention and all this. But the case that everyone has been talking about or so for the last year involves this Biometric Information Privacy Act. This is an act that says, look, if companies take your biometric information, so fingerprints, digital photographs that they then put through some software so that they can identify faces, that they're supposed to, get your consent to do that. They're supposed to keep it, secure. They're not supposed to provide it to third parties without consent, et cetera. And if companies don't do that, now they're subject to penalties, between $1,000 and $5,000. They're not huge penalties, except these kind of cases are ripe for class actions. And we're seeing cases out of Illinois that are ruling on, does the comp bar apply to these cases? I think the answer is no. The statute of limitation on these things, when does the clock start, et cetera. But the big thing, from my little world on insurance is, well, are these things even covered by insurance at all? and particularly CGL policies. You know, in this case, out of the Illinois Supreme Court, it's this West Bend versus Krishna Schomburg Tan sort of answered that question in terms of the language that we see in most commercial general liability policies. This was a business owner's policy, but close enough. Most of these policies will have some sort of coverage for what they call personal injury or personal and advertising injury. Because this was a BOP policy, they split the personal injury and the advertising injury into separate definitions, but same thing, right? And so under these policies, there is coverage, as we see here on the screen, for injury arising out of one of several offenses. And the one that is relevant for this BIPA stuff is damage arising out of oral or written publication of material that violates a person's right of privacy. And this is, a coverage grant. We see it on the BIPA stuff. You saw it on some cyber stuff, people trying to argue that CGL provide coverage for data breaches. You see it for, people spying on each other, providing medical records out of course to folks. So this ruling is super important for BIPA, but it goes far beyond this, And the two big things that you had to have for coverage, at least the duty to defend, is publication and a violation of a right of privacy. And what in the world do those two terms mean? Okay. And so Supreme Court of Illinois answered both of those. On the publication front, it's interesting. Like this opinion, when you read it, it's such an Illinois opinion. Okay. Missouri would not do this. There's different ways to interpret policy language. You can interpret the language literally as it is on the page. That's sort of a hallmark of Missouri. Or you can look at the language, but then also other things like treatises and, what does the industry think is covered, and articles. And it's sort of a more of a wide open approach to interpret what language is. Illinois does that. Okay. Illinois does not always interpret language literally. And you can see that here because they say, in order to figure out what publication means, and the debate was, to publish, do I have to tell a whole bunch of people or just one? If I just tell one person, is that publication? And in Illinois, you can see they reviewed dictionaries, they looked at treatises, they looked at the restatement, and they figured out, look, there's two different views on this, right? One person may be good enough, or maybe no, maybe you have to tell a whole lot of people. And because there was more than one reasonable interpretation of what the word publication meant, they said there was an ambiguity and we're going to rule against the carrier. And we're going to say, as it was in this case, because this is one where the plaintiff had, I think it was a fingerprint thing, and it was a local, tan company franchise, and they provided that information to a third-party vendor, was providing to that vendor good enough? Supreme Court said yes, right? Because there's an ambiguity, because we could see that there's different ways to view the word publication. Just providing it to one person could work. And since the term wasn't otherwise defined by the policy, we're going to rule against West Bend and say there's coverage there. I don't know if Missouri would do that necessarily. I think Missouri would, look at the dictionary. I mean, we actually have in the state like an official dictionary. I think it's Webster's Third or something like that. There's a case that says that. They may take a different view. And the other piece of it is, well, what about privacy? Do we have that? And, Illinois did again. First they start and they say, look, we again look to dictionary definitions. And then they have one sentence. Black's Law Dictionary defines right of privacy as the right to personal autonomy. That's it. That's the dictionary work. And then they spend the next couple pages looking at other stuff. What do Illinois courts think that privacy means in terms of tort cases? And then they go on, they say, let's look at the act itself. And the act itself talks about privacy. And so therefore, looking at all this stuff, we feel that there was a violation of the right to privacy, and therefore both of these key pieces of the agreement were met, at least for purposes of duty to defend. And so now under a lot of these policies, particularly CGLs, there may be a lot of coverage for these under the standard forms. I would anticipate ISO and the industry will now have endorsements coming out shortly that say that these claims are not covered. You have to buy special insurance for it. But in the meantime, could be quite a bit of coverage. It's interesting, not only for the BIPA stuff, but also to show, the really extreme differences between our two states and how they interpret policy language.
Michael, thank you. All of the attendees have your written material, and I know the Krishna, the West Bend Krishna cases on the 4th page of that material, and I call everyone's attention to those. They are rich and they are really important if you have any focus on 065 and the evolution over the past, 4 years or so. That's really terrific. Mike, thank you again for speaking. We are so fortunate to really have one of the experts in the country right here in our backyard and have you willing to speak to us. We thank you.
Absolutely. That's very nice of you, Rob. I appreciate the opportunity.
Folks, do not forget to submit your evals and provide us with suggestions for upcoming topics and speakers. And as I said, Kelly will email an evaluation form to everyone. And just a final reminder, go ahead and save the date for both April 22, June 22. We look forward to seeing you back at our next best practice programs. I hope everyone has a terrific rest of the day and a great weekend. Thanks so much.
Thanks, guys. Bye-bye.